Good afternoon. I usually give a warning when I'm going to go live, but I decided to just pop in today and do this live feed on estate planning. As many of you know, I am a licensed attorney. I've been practicing law for 25 years now. And the things that I see sometimes really bother me. But one of the things that I see people do to themselves and to their family that can be avoided is to die without leaving a plan for your estate. People will say, well, mama would have wanted us to do this and mama would have wanted us to do that. But if you just go ahead and say what mama wants while mama's still breathing, then your children won't be trying to figure out what to do. They won't be trying to figure out how to get the money out of your bank account because they can't. So y'all feel free to share this video with your friends and your followers so that they can get this information about estate planning. I have been interviewed about it before and I've talked about it before, but I just wanted to, allow y'all to be privy to some information that some people just don't have. First of all, a lot of times people only have money and a house in their estate. Most people don't have a lot of, different properties. Like you don't own like 12, 13 houses in different states. And you don't have all these money market accounts. You don't have intellectual property that has value. Most people just have like a house and some bank accounts. So if all you have is a house and some bank accounts, all you have to do is go to the bank, tell the banker that you want to sign a form making your open accounts payable upon death to another person. So like, for instance, I only have one heir at law, my son. And so my accounts are payable upon death to my son. My son is not a lawyer. So my law office account is payable upon death to a lawyer. So, so that he can, settle out my law office business and then give the rest of the money to my son. I own a home. So my son doesn't have to worry about trying to deal with my house, if I die, because I've already given myself a life tenancy in my home with remainder to my son. So that means that whenever I die, you can do whatever you want to do to the house while you're still living. Like you can get a mortgage on it, but you have a life tenancy estate in your own property with remainder to someone else. And then when you die, that person don't have to go and open an estate and probate an estate, open your estate up to creditors and all of that. Because what happens is people have a house in the estate and then they'll come to me and they'll ask me to get the house out of mama's name. Mama has died. And to get the house out of mama's name into the children's names. But in order to do that, I have to open an estate. And opening an estate is a lot of work. And most lawyers charge a minimum of about $7,500 to do that. And if all you have in your estate is a house and a little money, then the attorney's fees may just not be worth the effort. So if you go ahead and plan this before you die, then your children won't have to deal with that. They won't have to be trying to come up with money to pay lawyers. And you also won't be opening your estate up to everybody that you owe. Because when you open an estate, after the estate is open, the next thing you have to do is do a notice to creditors. So that means for 90 days, your estate is going to be open for creditors to come in and put a claim on your estate, and then no assets will be able to be disseminated until those creditors are paid. So you don't have to worry about that if you go ahead and deal with that while you still got breath in your lungs. It's just not rocket science. It's really, really easy to do. You have to make your wishes known. I have seen so many children fighting over estates and fighting over, no, mama wanted me to have this and daddy wanted me to have this. You don't have to do a will in order to do that. And you don't have to hire lawyers to do all that. You can do a holistic will, which is a will that is completely in your handwriting. And then you get it notarized by a notary. And you don't really have to get it notarized because you can get a handwriting expert. If it comes down to fighting over the estate, you can get a handwriting expert to do it. And you can say who you want to have your car, who you want to have your grandmama's pearls, who you want to have everything that's in your estate. But if you don't say anything while you're still living, then it's going to be left for people to try to figure out after you're dead. And that's just like kind of hard to do because nobody knows what you're thinking because you're not thinking no more. Come on. So, and the thing about it is I hate charging people that much for estates. You know, it's like you can do little things like if you can't get to the money and you need money to bury the person. You know, if you do the POD on the account, then as soon as you die, your money is payable upon death to the person, and all they got to do is bring a death certificate to the bank and they got the money out of your account to bury you with. And I mean, that just saves so much drama. It just saves so much drama. And then a lot of times people will leave a piece of property to one of the heirs thinking that that heir is going to be fair to the other heirs and disseminate it once that person is dead. And then that heir does not do what they're supposed to do. And then it's just a family feud all over again. So if you want to keep your family from fighting after you're dead and fighting over your stuff, then the thing to do is to plan your estate prior to dying. If you have property in your estate, then go ahead and deed that property to someone. You know, deed that property to the person that you want to have it after you die. You know, a lot of people will come to me and they'll ask me, can you do a will for me? And I'm like, well, what's in your estate? Because depending upon what's in your estate, you really don't need a will. You just need to do some deeds to go ahead and transfer that property so that it will be in that person's estate as soon as you die. Like you get a life tenancy in the property and then you give it the remainder to whoever you want to have it after you're gone, and you don't have to worry about that. Because what happens, I've had so many people who have called me and they mad because they say that, you know, my brother keeps coming on my piece of the property, and this is my piece of the property, and this is where my house is. But the house is still in your mom and dad's name. So you ain't got no piece of property. That whole thing belongs to all the brothers and sisters. So you ain't got no piece. All of it belongs to all of y'all. So y'all have to go and open an estate, be determined as the heirs at law to the people who previously owned it, then go and get a surveyor to come out so y'all can partition the land and determine who's going to get what piece. When what you could do is go ahead, you know your mom and dad ain't going to live forever. You go ahead and get them to say, Mama, who do you want to have what? Who do you want to stay in the family home after you die? Because we need to go ahead and do some deeds so that we can get that done and not have to be worried about it, you know. And no matter how young or old you are, if you have something and you have children, especially if you have more than one, I mean, it's not no question about who's going to get my stuff when I die. I got one child. So there's no question. Ain't nobody going to be fighting over my stuff. My son gets everything when I die. So it's just like, but if you have like a husband and then you have children, like say for instance, you get married later in life. I've seen situations where somebody got married later in life and then the children got disinherited by the actions of the parent that married the other spouse because they gave the spouse a joint tenancy with rights of survivorship. So when that person died, then the property went to the other spouse. It didn't go to the children. The children couldn't even get to it because that deed is going to take out. That deed is going to decide everything that happens. So if you have children and you do a joint tenancy with rights of survivorship to your spouse, then your spouse is going to get the whole thing when you die. Your kids ain't going to get none of it. So you have to know the difference between a joint tenancy with rights of survivorship and just a co-tenancy where you own your half, I own my half, and then when we die, my half going to go to my kids and your half going to go to your kids. So it's just like you need to get somebody to explain these things to you, but it's so much cheaper to do it while you are yet alive. It's so much cheaper to do. I know a lot of y'all be like, I don't care. My kids can deal with it however they want to deal with it after I'm gone. But you just don't realize siblings have killed each other over what was left in mama and daddy's estate. It's just not worth it. Go ahead and prepare some deeds. Have some deeds prepared, transferring your property from yourself to yourself with a life tenancy for yourself with remainder to your children. And then go to the bank and put POD on your accounts so that when you die, people won't be trying to figure out how to get your money out of the account. Because if you have a power of attorney, that power of attorney dies with you. Even if it's a durable power of attorney. A durable power of attorney lasts after you are no longer of sound mind, like if you get dementia or something, or you go into a coma. A durable power of attorney will outlast that, but a durable power of attorney or a regular power of attorney, neither one of them will survive your death. Once you die, that power of attorney dies with you. So then you're going to have to open up an estate if you have not made provisions for what you want to happen to your assets after you're dead. So if y'all have any questions, put the questions in the comments. I'll be more than happy to answer them. I decided to give out some free legal advice because people are dying of COVID. People are dying of different diseases, and there's no will. There's no will, and there's no property, no explanation as to where the property is going to go when that person dies. And that's just so important. That is just so important. Because if you don't have nothing in your state but a little money and a house, you can handle that before you die and stop your children from having to go and pay a lawyer close to $10,000 to open up an estate and open your estate up to creditors so creditors can come in there trying to get your money too. And instead of doing that to your kids, you can just go ahead and do some deeds and then do the payable upon death at the bank and save your kids a bunch of money. If all you have is a house and what's in your house and, you know, some money in the bank. Okay? I'm just trying to help y'all. I've seen it so much, and I've seen people who've done it the right way. I had a lady that came to me several years ago, and she went ahead and did deeds for her sons while she was yet alive. And so all her sons had to do was call me, and I was able to email them a copy of the deeds that their mama did 5 years ago. So, you know, that just saved all the drama of having to deal with that after she's gone. It saves the drama of your siblings trying to decide which piece of property is theirs and which part of the property is yours. It just saves you so much. It saves you so much drama. Because I've seen so much of this. And I mean, you know, I took wills and estates, I took future interest and trust, and I took property law in law school. And all of this stuff is handled in these situations. So you got to make sure that you do. Okay, Alice said, are your children responsible for your debt? Alice, that's a good question. And the reason that I'm doing this is because your children can be responsible for your debt. Like, for instance, if there's a mortgage on your home, if they want to keep the home, then they're going to have to pay the mortgage, because when you die, that don't pay off your mortgage, your debt, unless you got credit life on your home loan. Other than that, the mortgage is still going to be owed. And if you have a car and you still owe a car note on that car, then whoever's going to get that car has to pay that car note, or that car is going to be repossessed by the finance company, unless you have credit life on that loan, on that car loan. Also, like I was saying, if you go ahead and deal with your assets before you die, then that will limit a creditor's access to your money. Like if you have credit card bills or you have student loans and all of that stuff, if you have to open an estate to have the court to determine who's going to get what, you also have to file a notice to creditors so that the creditors can come in and take their part. So it all depends. So if you go ahead and do the deeds, do your bank accounts, make your bank accounts payable upon death, go ahead and put your beneficiaries on your life insurance policies, go ahead and transfer your property to who you want to have it when you die. All you got to do is sign a deed saying that I, Gay Polk-Payton, do hereby convey unto Gay Polk-Payton a life estate in the property located at blah, 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 with remainder to Gabriel Payton, my son. And once I do that, that means that as soon as I die, my son gets my house. He don't have to go and do nothing. But if there's a mortgage left on my house, if he wants to keep the house, he's going to have to pay the mortgage, or he's going to have to sell the house. And then, you know, he can keep whatever equity is left in the house. But my bank accounts are POD. So that means payable upon debt. So all you have to do is add that to your bank account. It's, you sign one sheet of paper. It's so easy to do, to just go and put your bank accounts payable upon death, and then your money will go to your kids when you die. Does anybody else have any questions? Anybody? I'm doing good, Mr. Estes. Thank you for asking. But that's the only way that your children will be responsible for your debt, if they want to keep an asset that has a lien on it and doesn't have credit life on it to pay it off when you die. Or if you have to if they have to open an estate, that will also open up your estate to creditors. But if you go ahead and handle your business now, then you don't have to open an estate, and then that will limit creditors' access to your property after you're gone and your money. Okay, so y'all share this with your friends so that they can get this information and learn more about estate planning. And it sounds so complex. When people think about estate plan and they get confused, they be like, oh my God, I don't want to deal with all that. But really, if all you have is a house and a little money in your estate, you can handle that by having a lawyer to draw you up a deed and going to the bank and having your bank account listed as payable upon death to whoever you want to pay it upon death to. It's really more simple than it sounds when you say estate planning. But like I said, if y'all have any questions, you can inbox me, or you can put the question below. And when I see the question, I'll answer it to the best of my ability. Just save your kids some drama from having to deal with some drama after you are gone, especially if you have more than one child. If you have one child, then it won't be as complex. But if you have more than one child, I'm going to give you an example. I'm going to use my family as an example. So my daddy died 3 weeks before I graduated from law school, and my mother died 17 months later when I was pregnant with Kobe. Okay, so they died within 17 months of each other. Then my baby sister had a wreck after my mom died, and it was easier to deal with the car. But maybe after a year or so after my mom died, the house burned. It was a total loss. The house was a total loss. And so my parents had insurance on the house. But in order for us to deal with the insurance company about the damage to the house, we had to have somebody who was the administrator of the estate. It was 4 of us. So one of us was going to have to be the voice, and who was going to be able to sign the checks and sign the releases and all of that. So I went in to go and open my mother's estate because she was the second one to die. So I went to open my mother's estate, and then when I went and did a title search to look for the deed to the house, my mama's name wasn't on the house. It was just in my daddy's name. So even though the house was paid off, it was still in my daddy's name. So what I had to do was I had to open up an estate for my daddy, have my mother and us, the 4 kids, declared as my father's heirs at law, and then I could probate my mother's estate. But I couldn't probate my mother's estate until I probated my daddy's estate because her name wasn't on it. So I had to get her named as one of his heirs. And then in her estate, we were named as her heirs. So it's just like, my parents could have easily given themselves a life tenancy, a joint life tenancy in their own estate in the house with remainder to the children. But, it's like, and I probably would have done that for them. But, my dad died before I graduated from law school. And then my mother died so soon afterwards. It's just like kind of, and then I was pregnant and had just got married 2 years before that. And so it was just a lot going on. And so I didn't get a chance to do all that and to set up their estates. But I'm making sure that my son doesn't have to deal with all that. I've even done my funeral program all the way down to who going to be toting my ashes at the church. I've done the whole program. What songs are going to be sang, who can talk. All of that has already been done. And I've emailed it to several of my friends so that the ones who survive me will be able to make sure my wishes are met. So it doesn't take a lot. One thing you got to admit is that you're going to die one day. Just as sure as you were born, you're going to die one day. So you may not want to deal with the fact that you're going to die one day, but that ain't going to stop it from happening. So the best thing to do is not to be anxious to die or be ready to die, but you need to be prepared to die. And you need to have your asset prepared for your death. Otherwise, you're going to leave a mess for your children to clean up. Okay? All right. Well, that concludes My public service announcement today about estate planning. If anybody has any questions, put it in the comments and I'll be happy to answer it to the best of my ability. I hope y'all have a wonderful evening. Stay safe out there. Adhere to the COVID guidelines. Wear your mask. As the little man said, wear your mask. Wear your mask. Wear your mask and make sure that you don't make it about you. It's about other people. Care about other people enough to put a mask on. Make sure you get COVID tested. Thank you, Sarah Hose. Just do what you can to look out for other people. This is a pandemic that we're in, and that means it's not every man for himself. It's every man for each other. All right? Y'all have a good night. Bye.